What is the power of augmentation? Under the 1987 Constitution, the power of augmentation is the power of the President of the Philippines, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of the constitutional commissions, when authorized by law, to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. When the appropriation for particular item in the respective offices of the above-mentioned officials are deficient, the same can be augmented from the savings in other items of their respective appropriations. How should the power to augment be interpreted? Jurisprudence provides that the exercise of the power to augment shall be strictly construed by virtue of its being an exception to the general rule that the funding of programs, activities, and projects shall be limited to the amount fixed by Congress for the purpose. Necessarily, savings, their utilization, and their management will also be strictly construed against expanding the scope of the power to augment. Such a strict interpretation is essential in order to keep the executive and other budget implementors within the limits of their prerogatives during budget execution and to prevent them from unduly transgressing the Congress's power of the purse. What are the requisites for the valid exercise of the power to augment? According to jurisprudence, the transfer of appropriated funds to be valid under the Constitution must be made upon a concurrence of the following requisites. First, there is a law authorizing the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of the constitutional commissions to transfer funds within their respective offices. Second, the funds to be transferred are savings generated from the appropriations for their respective offices. And third, the purpose of the transfer is to augment an item in the General Appropriations Law for their respective offices. Allow me to give some case questions to better understand the power of augmentation. Here, the executive department pulled together the funds to finance its priority projects under the disbursement allocation program system. The system of pooling of funds was used to accelerate government spending. The funds were sourced out from unreleased appropriation and withdrawn appropriation as they are treated by the executive department as savings. Question: can the funds sourced from unreleased appropriation or withdrawn appropriation be considered savings for the application of the power of augmentation under the Constitution? The answer is no. The funds which were sourced out from the unreleased appropriation and withdrawn appropriation are not considered savings. According to the Supreme Court, savings under the Constitution in relation to the power to augment refers to portions or balances of any program appropriation in the General Appropriations Act that is free from any obligation or encumbrance which are, first, still available after the completion or final discontinuance or abandonment of the work, activity, or purpose for which the appropriation is authorized. Second, from appropriations balances arising from unpaid compensation and related costs pertaining to vacant positions and leaves of absence without pay. And third, from appropriations balances realized from the implementation of measures resulting in improved systems and efficiencies and thus enabled agencies to meet and deliver the required or planned targets, programs, and services approved in this act at a lesser cost. In other words, the power to augment was to be used only when the purpose for which the funds had been allocated were already satisfied or the need for such funds had ceased to exist, for only then could savings be properly realized. If this is the definition of savings under the law, then unreleased appropriation and withdrawn appropriation are not considered savings. Next question. Can the President use the savings to augment an item that is not provided in the General Appropriations Act? The answer is no. The President cannot fund through the savings an item or items not provided in the GAA because it is a violation of the Constitution. Under the Constitution, the item that may be augmented must be an item in the GAA. Thus, a non-existing item cannot be augmented. Further, it will violate the constitutional provision that no money shall be paid out of the national treasury except in pursuance of an appropriation law. If there is no congressional authorization through an appropriation law, public fund cannot be disbursed. Another question. The General Appropriation Act provides Section 59, Use of Savings. The President of the Philippines, the Senate President, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, the heads of constitutional commissions enjoying fiscal autonomy, and the Ombudsman are hereby authorized to augment any item in this act from savings in other items of their respective appropriations. Is the provision valid? No. Such provision in the GAA is unconstitutional. The subject section of the GAA does not carry the phrase for their respective offices. It may imply that the savings may be applied to augment any item even outside the respective offices of the officials endowed with the power to augment. Thus, said provision is not valid as it is not in conformity with the constitutional limitations of the power to augment. Here's the last question. Supposing the legislative department's appropriation is already deficient and there are no more remaining savings that the legislative department could use, can the president transfer the savings of the executive department to the legislative department, assuming that he is empowered by law? The answer is no. The president cannot do a cross-border transfer. Jurisprudence dictates that the augmentation must be limited to items in their respective offices from the savings in other items of their respective appropriations. Thus, cross-border transfer of funds is constitutionally prohibited. The Supreme Court further explained, to be sure, the phrase respective offices refers to the entire executive with respect to the President, the Senate with respect to the Senate President, the House of Representatives with respect to the Speaker, the Judiciary with respect to the Chief Justice, the Constitutional Commissions with respect to their respective chairpersons.